Yes, welcome to another edition of the No Say Project. I had a quick video here. We got another success story. Yeah, baby, that's right. We keep racking up the dismissals and another dismissal with prejudice. I did mention this on the big show yesterday, but I wanted to get a separate article here under the success stories and get the document actually posted. And I'll also get that posted for the archive of the radio show. But this is great. Like I mentioned yesterday, yeah, we just keep racking them up here. Regardless of what critics will say, we have plenty of success stories, plenty of them on three continents. So if you're just new to the website, you're new to the material, don't let anyone talk you out of defending yourself. It's not necessarily easy, but it doesn't mean and it's a little daunting. I get that. That's why we have the role playing. We do a lot of prepping. We have the radio show to help you through the process. So don't let anyone tell you that you cannot win because we get these things tossed out all the time. So let's get to the actual document here because that's why we're tuned into this. There it is. Not the best. It's from a phone, but I do appreciate Christopher for providing this to me, and also congratulations on sending this. This just happened this week on August 25th, 2017. And they're in Texas. I made the mistake yesterday. It is Texas, not Tennessee. So, what we see here, it is the heinous crime of operating an unregistered vehicle. This is non-compliance. Not that he actually committed a real crime. This is non-compliance. They treat it like it's a real crime anyway, because hey, they're criminals. So what it says here, the county attorney has made a motion to dismiss the above case, and Judge Grimes has signed an order that it be dismissed. A copy of this is enclosed for your records. We will not be having a jury trial on September 11th, as this case has been dismissed. That is some serious Photoshop work there, I got to tell you. Yes, the Justice Court in Cherokee County, Texas. So some of the details that Kris provided during the show yesterday was this took over a year, and he did file the motion to dismiss. He did file the Brady request, and the prosecution was totally unable to provide the evidence. And the reason why we push that so hard is because the burden of proof is actually on the prosecutor. This is fairly well known, but not everyone may remember this. The burden of proof is usually on the person who brings a claim in a dispute. It is also often associated with the Latin maxim semper necessitas probandi incumbit et qui agit, a translation of which in this context is the necessity of proof always lies with the person who lays the charges. The party that does not carry the burden of proof carries the benefit of assumption of being correct. They are presumed to be correct. That's why they have the presumption of innocence. Until the burden shifts after presentation of evidence by the party bringing the action. Yeah, until the evidence. And so what the prosecution wasn't able to do in Kris's case, in any of our cases, is present any actual evidence to support their claims. Their claims are all based on a single allegation, which is that if you're physically in Texas, then these magical rules called laws apply to you. But there's not a shred of evidence. But you see here, you're supposed to be presumed innocent until the burden shifts after presentation of evidence. Now, before trial, that's prima facie. They have to tell you what they have. During trial, it is beyond a reasonable doubt, which is a different standard, but they still have to have the damn evidence, which of course they do not do. They don't have. So Kris also followed up the motion to dismiss and the Brady request, which the Brady request, of course, being asking for Brady material, which is any information that has a tendency to show that you are innocent, or it can be used to impeach the prosecution's witnesses. Now, this is where, and this is Texas rule. You can see it's Texas court. Rule 602. It's almost pretty much identical word for word for the federal rule. And so what we're asking for, want to know if the witness has personal first-hand knowledge of the matter, because it says a witness may testify to a matter only. See, it's only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. What are they testifying to in Kris's situation and pretty much everyone else? That's right. They're testifying that you are subject to the law and did not comply with it. So, by Rule 602, where do we got that here? By Rule 602, they have to have evidence sufficient to support a finding that the witness has personal knowledge that the laws apply and you violated them. They don't have that, which is what prompted Kris to file the motion in limine, which is a motion to restrict a party's argument and evidence. If the witness and the prosecution has no witness with personal knowledge, they should that the laws apply, they shouldn't be allowed to argue that they do. Okay, that's just basic principles of fairness. He also filed a motion to dismiss for prosecutorial misconduct because of this right here, because the prosecutor is arguing without evidence and is planning on bringing a witness that does not have personal knowledge. Remember, a witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. They wanted to go ahead anyway, and they wound up filing, as we see here, which we've gotten so many times. We've gotten a motion to dismiss from the county attorney dismissing their own complaint, and it was dismissed with prejudice, which is a big win. They can't ever refile it against Kris. So big congratulations to Kris for standing up to those predators down there in Texas, Cherokee County, Texas. If you believe that the prosecution that I'm wrong, that the prosecution could have proven that the laws apply, that they did have the evidence, and that it was dismissed for some other reason with prejudice, hey, I love to hear your evidence. Not speculation, not based on what's happened in other cases. We want to hear some evidence for this particular case, because as it stands, we have got yet another dismissal with prejudice. So again, congratulations to Kris for standing up to these predators. I thank you for providing that. And if you are being attacked by one of these bureaucrats, one of these predators, and you want to learn what has proven to be a very effective method for getting tickets thrown out and complaints, and whether it's taxes or traffic or drugs, on 3 continents, three continents, then hey, give us a call to a live broadcast. We'd love to help you through that. Yeah, my name, and we do have, where is it over there? We do have the Skype chat that you can get into that helps with that also. Again, my name is Marc Stevens. This has been another edition of the No State Project, the success stories. Till next time.